the only notable win for non-citizens in December, tragically. Although, the circuits do shut down a bit in December. But Song v. Garland was an interesting one out of the Fourth Circuit. And it regards a published BIA decision matter of Song. So that's always interesting. And it's about K-1 visas, which I know you deal with probably more than me, and there's very rarely decisions on K-1s.
Yeah.
And so I thought it was interesting. I thought you might want to talk about it. It's about the I-864 requirement to become a conditional LPR after entering as a K-1. In this case, Miss Song's marriage kind of disintegrated. Nobody's alleging marriage fraud, but her husband withdrew the I-864 after he filed it, before she adjusted to conditional permanent resident status. And eventually she gets a substitute sponsor. So like, she's got the sponsor, she's here, she's not going to become destitute, she's not going to become a burden on the US government, but the BIA, and then here in this case, the Fourth Circuit said, for K-1 conditional adjustment, it's got to be the petitioning spouse. There's no way around it. And that's, quite frankly, back to our discussion just now, it's based on the statute.
Yeah, it's an interesting matter. I mean, someone had posted in one of the Facebook groups too. They actually know this. They got this case denied because they, K-1 comes in, doesn't marries the initial K-1 sponsor, whatever, but they separate. You remarry a U.S. citizen, you can't adjust status. Or if that I-864 sponsor continues the sponsorship, you can, but they're probably not because they don't like each other. So they're gonna withdraw it unless you do like asylum. You got to go, and you're probably gonna be subject to a 3 or 10-year bar at that point too. So that situation.
I got to amend actually what I just said. This is actually This is actually the text of the regulation, not the statute itself. Similar thing, but the circuit doesn't defer really nearly as much to the agency when it's the plain text of the regulation. It's just determining whether the regulation is reasonable, or here whether the BIA was reasonable. So in this case, less, the DOJ, DHS could write new regulations. The Biden administration could say, this isn't right, we don't like that reg, take it away, and then you'd have a different decision. And the argument was made, as was made in the Facebook groups, as they're kind of saying, like you were referring to, is like, look, this puts a lot of power on the petitioning spouse, risks abuse, risks situations that are dangerous for the K-1 conditional, LPR applicant.
It puts them prisoner, kind of. It's kind of it creates a viable potential situation on its own. Yeah.
But, the BIA did say in matter of Song that there are exceptions for abuse and death, and that's a quote, pretty cryptic. But the BIA and the Fourth Circuit also said, I mean, this is interesting. I don't know how real world it is when you're thinking about, a foreigner coming to America, already pretty dependent on the non-citizen. But, the quote is, the BIA said, like, quote, a divorcing applicant could agree as a negotiated term in divorce not to sue the sponsor for breach of his contractual I-864 obligations, which survive divorce. So, like, you'd have them like have any hand in divorce, but I do think most states allow for like no fault divorce, right? I mean, I don't know how. I guess there can be suits a lot. I think that's a heavy price to ask for someone who, by definition, has just come to America because they're a K-1, right? To say, all right, now you're getting divorced, negotiate them to sponsor you, and that you're not going to sue them, so you can become a conditional LPR. They could do that. It's a heavy ask. The Fourth is saying, well, look, the K-1 is only here because they married a U.S. citizen.
Yeah.
So it's not so crazy to say they can only stay here if supported by the U.S. citizen. I guess reasonable minds could differ.
Interesting thing is, right when this came out, I got a consultation for a guy who got divorced, and he was calling about what the responsibilities of the I-864. And I told him, well, you can't get out of the government responsibility. That contract, the government's solid until the person naturalizes or yada yada, 5 different things. But then we started digging deep in that language. I went and looked up when the statute or the regs were updated on this. And in the commentary, they said that potentially you could negotiate to get out of a divorce, out of the responsibility, I-864 sponsorship from the person. But they said it in this haphazard, like offhand kind of way. But so if you are in a case where you're dealing with a petitioner and they're divorcing, that's some advice in divorce. His lawyer hadn't told him about that. He got stuck with it. And he's like, am I going to pay I-6 for sponsorship for the rest of my life? I'm like, if she doesn't naturalize,
Right,
yeah.
right.
Now, I was researching, and there's one attorney in Seattle, Mick Lawson, I think, who's like the expert. He's the number one guy for suing on these on the beneficiary applicant side. And his website was saying that a lot of state courts find it objectionable to have in perpetuity payments like that. So they'll in divorce proceedings, it's best to negotiate if you're going to do it. But it's kind of a weird situation. Let's say the sponsor was like a good guy, though. The foreign spouse gave him some crazy whack or something like that. Who knows? Being stuck in perpetuity if they don't naturalize is kind of a tough thing to have in there. So just an interesting thing that popped out of that situation.
Doesn't that create, though, another problem? Yeah, no, it seems like everyone is agreeing that that is a possibility, but doesn't that create another problem whereby then you have somebody without any sponsor in America, right? You're kind of getting
Yeah.
around the I-864 purpose.
Yeah.
You don't have to, the non-citizen doesn't have to have a substitute sponsor. I mean, there'd be no ground of removability, right? Based on your lack of sponsor once you are an LPR. So that is, unless I'm missing something, kind of a way to blow up the entire sponsor framework in American immigration law.
I mean, the part of the government stays there, so they get food stamps or benefits. But yeah, but the day-to-day money thing, yeah, they got it. So yeah, it doesn't.
Okay, the part for the government stays there, so you have to prevent them from going destitute.
Well, the government part is just the taxpayers, but the destitute part is still. I mean, they're not getting
Right.
support. And maybe they should make a timeline of like 5 or 10 years, and then that's it instead of perpetuity. Maybe that'll solve that situation. So it gives them some runway to figure it out, and then ends. Because just in general, like if you're a joint sponsor for somebody and you sign the I-864 and like what if for the rest of your life you got to be on the hook for that? I mean, I have disclaimers I give to clients. Some law firms won't do I-864s. There's some local law firms here. I say go get a separate attorney for a marriage adjustment, for example, happy to support. Or they won't do the paperwork for joint sponsors. They don't want to get involved in this. But the perpetuity aspect of it is kind of unconscionable. One or another, they should add they have the thing where if you work for 10 years and 40 quarters or blah, blah, blah. But what if they don't work 40 quarters? That's a lot of time. There should be some sort of end. That should actually something that needs to have an end to it. It's kind of crazy. It should be there, but it should at the same time have some sort of end to it.
Well, for K-1s, you got to have the petitioning spouse be the sponsor. It says the board, and now the Fourth Circuit says that that's A-okay. So
I think that's going to stick. Yeah, I mean, it's pretty solid. So you got to know that that's a pretty solid way the K-1s are going to work. Just another reason not to do the K-1 and try to go marriage if you can.
Right. No, it's serious. I don't know why anyone does the K. Well, I mean, if you want to marry in America, I suppose.
Yeah, I've had it where it was same-sex couples who couldn't get married because of like laws in foreign countries. I had some people like, oh, we want to have our wedding in the U.S. together, this and that. And all of them regret it. They're like, oh, I wish you just got married, got done with it. Because once they come, they got to file for adjustment status, and it takes a year, some field offices, and it's like, just get it done. Like, there's no point of that.
And multiple times last year, I got I-765s approved pending adjustment after the green card was issued.
There you go.
Or I've gotten 765s denied after the green card is issued based on USCIS saying the person's now a green card. It's like, guys, this is supposed to be pending adjustment. It's been a year. You hadn't had employment authorization for a year. That's a whole nother conversation.
Another reason why the K-1 is like not a good idea. Just get the LPR stats, come in and get it up and running.
Yeah.
I mean, it's there, and a lot of people sell that. So I go on tangents about the K-1. I don't like it, but there's the idea that it's faster or stuff like that, which is like barely. It's like it's not worth it for most cases.